Good afternoon, everyone, and welcome. I'm Suzanne White, Education Manager for the chapter, and thank you so much for being with us. I want to take a moment to recognize all of our annual business partner sponsors for their continued support of the educational programs here at the chapter. Today's sponsor is Landmark Payroll, who has put together today's speaker panel as well as a timely and practical presentation on human resources best practices, a topic which can be complex and confusing. I'd like to go over a few housekeeping rules. All of you are muted. If you need assistance during the session, I will be monitoring the chat window. If you are calling in, please chat your number and name so that we can ensure that you are marked as attended. Additionally, if you have any questions for our speakers, you can submit those questions in the Q&A box during the session. We will get to as many of those questions as we can as we get towards the end of our time together today. Now, please join me in welcoming today's speakers, who will do a much better job of introducing themselves than I could. Take it away.
Hello,
Hi.
everybody.
Oh, go
Go on.
ahead.
Hello, everybody. I'm Joe Israel with Landmark Payroll. Thanks for coming. I appreciate it. Corinne?
I am Corinne Doherty, and I'm HR business partner at iSolved. Nice to meet you.
Hey everyone, my name's Emily LeBlanc Thompson. I work closely with Joe from the HR services here at iSolved.
And I'm Sarah Gerstein. I'm the general manager of Broadlands Association. We're a master plan community with over 4,000 units in Loudoun County. I'm responsible for the HR of our small team. We have 12 to 16 employees, depending on the some season. And something we're not typically trained on as community association managers is HR.
All right. Well, I appreciate everybody coming today, and I'm looking forward to getting to know your businesses a little bit more if there's any additional questions. So today we're going to cover state and federal employment laws and why they matter. Um, So the objectives are how jobs are directly affected by a variety of state and federal employment laws. We're going to identify the requirements of these laws, using your knowledge to assist in compliance and interact fairly and correctly with employees. And again, we both have Emily Thompson and Corinne with iSolved. So we will be going through our presentation today. So what is HR
Before
compliance?
before we hop in, Corinne, I know
Sure.
I'd like to kick it on over to Joe for his kickoff blurb and intro.
Oh, sure.
Thank you.
No, I appreciate that. Just want to let you know Landmark is a sponsor, and Landmark Payroll has been supporting small businesses for many years, and our entire model is built around providing payroll services to our clients with 1 to 150 employees. So we understand the realities of running a small businesses because that's who we serve since day one. Landmark Payroll provides a full suite of payroll and HR solutions just designed to make your life easier. Everything from payroll processing, applicant tracking, PTO tracking, electronic onboarding, time and attendance, and even job costing. What really sets us apart from the big national vendors, when you need help, you get a real live human being who knows your business needs. No call centers, no ticket inquiries, no getting bounced around, just direct support when you need it. In fact, like 60% of our clients come from ADP or Paychex or Paylocity because they just want better service and a partner who pays attention. Beyond payrolls services, we offer 3 levels of HR support. You can choose exactly what your business needs. That includes live HR support on demand, custom employee handbooks maintained by HR partners, I-9 audits, full description library, hire, termination, FMLA and state leave guidance, background checks. And even if you want to even fully outsource your HR department, we can do that too. At Landmark Payroll, our goal is to give small businesses and tools, expertise, and personal support they need to run smoothly and confidently. Thanks for letting me get that in there. Please, so I'll let you run on.
Oh, no,
Go.
you're
Yep.
fine. I apologize. So, what is HR compliance? It is a practice of ensuring all company policies, procedures, and practices are in line with relevant laws, regulations, and best practices. This doesn't mean that compliance is only related to HR department. HR compliance actually touches all employment-related laws and regulations. It can mean following Department of Labor requirements for CDL drivers, having proper times for break times for employees, or providing lactation breaks for workers in 6 different call centers. Even if you may not have HR in your job title, compliance still touches your role or responsibilities. So, what are the basics I should know for federal state compliance? The Federal Compliance Continuum chart below gives you a good overview of very common federal laws that most employers are going to comply with. You may be familiar with this compliance continuum. It's an extensive list, but it's not exhaustive, of the main federal employment laws employers can expect at different sizes. The numbers above represent employer sizes and which federal laws are applicable to them. Later in this presentation, we will also discuss some state-specific laws to be aware of as well. So let's begin breaking this down a bit more on common employer sizes and discuss a few key laws from within each. These are laws that are applicable with employers with 1 or more employees. So below, under FLSA, Fair Labor Standards Act, it establishes minimum wage, overtime pay, record keeping, and youth employment standards. The current salary threshold for an exempt employee is $684 per week, which is an annual salary of $35,568. In mid-2024, there was a ruling to increase the threshold over time to $844 per week on July 1st, 2024, and then another increase to $1,128 per week. And that was to begin on January 1st of 2025. Those were major increases that employers were preparing for. However, this ruling was vacated in November of 2024, restoring the 2019 threshold of $684 per week. This is a great example of how important it is to stay updated on state and federal laws as they can change with little notice. Next would be the EPA, the Equal Employment or Equal Pay Act. It prohibits employees or employers from paying employees differently based on sex for the same work. So things to stay away from: paying men and women differently for the same work, paying less than minimum wage. What you should do is evaluate jobs for levels of skill, their effort, and their experience. Paying overtime is also required when you have somebody who is in an hourly non-exempt role. Again, employers with 1 employee or more it's going to have USERRA, which is Uniform Services Employment and Reemployment Rights Act. USERRA protects the job rights of service members and veterans. This can be active service members and main branches of the military, the National Guard, local units, and veterans. Things to stay away from would be terminating employees or taking away their benefits, denying promotions, raises, or other opportunities, and refusing to reemploy a worker returning from military leave. What you should do is ensure a smooth transition upon their return. Keep in touch with the employee while they're on leave. Maybe things have changed and they're not able to return to work when they expected, when they originally anticipated. Accommodate employees. Help returning workers readjust to the job. Sometimes it takes a while for them to return from overseas, and it does take some time to readjust into a role. Sometimes things can change. Maybe their work has changed and you need to update them whenever they return. Be flexible. Employers with 50 or more employees are also applicable with FMLA. You want to stay away from preventing an employee to take leave, denying intermittent leave, refusing to reinstate a worker that's returning from FMLA, taking away accrued benefits. What you should do is check eligibility status, require employees to give notice of leave, ensure their jobs are adequately covered while they're gone, and keep in touch with them on leave. Accommodating the need for intermittent can also be something that you should be aware of. Maybe they are able to return from a consecutive leave, but intermittent may continue on. Employers with 15 or more employees would be covered under ADA. There are times when an employee may not qualify for FMLA, but they may qualify for ADA. It is really good to consider all possibilities, including ADA or other state laws that may be applicable to that employee, before proceeding with separation of employment to avoid potential risk. ADA prohibits discrimination against individuals with disabilities, including both employees and candidates. So it doesn't just start at whenever an employee is actually hired, it actually starts before the employee is even hired onto your company. Stay away from retaliating against an employee who requests, uses, or raises concerns about an accommodation, asking legal or inappropriate medical questions, make assumptions about an employee's capabilities, refusing to employ a candidate if their accommodation is reasonable. What you should do is engage in the interactive process by having a conversation with the employee and documenting the process in each step of the way. Focus on the job essentials or the essential functions of their job. We don't want to get carried away with the little things that they may not do on a day-to-day basis. Train managers regularly to recognize accommodation requests. Many times, managers are not able to recognize maybe the employee isn't actually coming out and asking for an accommodation, but rather having a conversation letting the manager know that something's going on. And if you train your managers, then they're able to recognize a potential accommodation request. Maintain confidentiality is going to be the biggest thing. HR is always about confidentiality and documenting conversations. Again, with employers with one or more, so this will be applicable to all employers. All employers must fill out or complete a Form I-9. E-Verify is only required by some states. It's not required by all. So we will discuss your states as well. Form I-9 is for all U.S. employees, and they must complete a Form I-9, and the employer's responsibility is to retain a copy of that I-9. All required fields must be completed within a certain time frame. For example, Section 1 of the I-9, employees complete it on or before their first day of work. Section 2, employers or the authorized rep of the company, they complete their portion within 3 business days of their hire. The new I-9 form allows blank fields if it's not applicable. The old form, you had to put something into each column regardless if it was applicable. Employers cannot require specific documents from employees. As long as the employee comes to work prepared with whatever form of identification is acceptable on the I-9 form, employers are required to accept those documents. You cannot require an employee to come in, I want your driver's license and your social security card. You cannot require specific documents. Remote employees are becoming more and more common in today's society. So when it comes to verifying a remote employee's I-9 form, it may be done via live video with obtaining the copies of the forms, and employers must check the alternative procedure box when they're completing their portion. Or the other alternative is using E-Verify. Getting into E-Verify, DC and Maryland, they actually do not require E-Verify to be completed. Virginia, however, they do require for all state agencies and public contractors that have an average of more than 50 employees in the last 12 months. Retaliation can apply to any employer size on federal or state employment laws. So things to stay away from is taking adverse action on an employee who complains about discrimination, cooperates with an investigation, or opposes discrimination or harassment. What you should do is keep complaints and investigations confidential, Avoid harassment or negative treatment, and document, document, document. The HR world is so crucial in documentation because if it's not documented, it doesn't exist. So that's the biggest thing that you want to focus on.
You're going to hear me say a little bit of the same about the documentation. So here's a little bit of fun. So you've terminated an employee, and what's next? Maybe they didn't return some equipment, they didn't turn over what their passwords are. You might have just paid a lot of money to send them to a class or a conference, or maybe they charged something to a credit card without getting approval. So what can you do about it? The number one question, can I just deduct it from their paycheck? I was literally on a text string last week and this question came up. And the short answer is no, you really can't. There are only two conditions under which you can withhold money from their final paycheck. The first one is the employee gave you written authorization for the deduction. Common example of this is going to be a signed employment manual, keyword being signed, where the company policy very clearly states the company will pay for training if and only if the employee stays for 12 months following the training and outlines what happens if they don't. Another example might be, a credit card policy or equipment policy that they have signed about what they can and cannot purchase, how unauthorized purchases are handled, and what happens if the equipment is not returned or is returned in a condition that is unusable. The second time that you can withhold is if they were given advance wages for time they hadn't yet worked. Outside of these circumstances, withholding their pay is completely illegal. So in reality, what do? Whether or not they've taken anything, the first thing to do is protect your data. You probably need to involve IT in this. Change your passwords immediately, all of your passwords, email, any software that they have access to, timesheets, things like that. Disable their email, their access to the VPN, the access to shared drives. If you have this tool, a remote lock or remote wipe can be helpful. Think of it like you're closing every door behind them as quickly as possible, like scoot them out the door. Third, you're going to identify and document any of the missing equipment or unauthorized purchase. So what equipment were they issued? Laptops, keys, key fobs, phones, uniforms? When were they issued this stuff? If you start tracking from the time you hire, it's going to make it a lot easier down the road. Just even if it's a little spreadsheet that has the employee's name and then, over the years, what you have issued to them and when, that's going to be really helpful when it comes down to retrieving these assets. Document the serial numbers that are on the equipment, the replacement value, or what the cost is of the purchases. Log into your credit cards and see what has been purchased since your last statement. Document what you've done to try to get the items back, all your communication with them. If it isn't documented, it didn't happen. So what do you actually do physically to try to get it back? Basically, you send a formal written correspondence with a deadline for returning the equipment or reimbursing the association. Send it by regular mail, send it by certified mail, send it all the ways so that they can't claim they didn't get it. If you include a prepaid shipping label, that removes their excuse for not being able to return it because they didn't have the appropriate way to ship it. If the items or the reimbursement still don't come back, you might have to file a police report or notify your insurance company. You might have to take them to court. I actually had an employee accidentally pack a $3,700 camera and equipment into a moving truck she sent to Florida. She also signed up for 2 online courses 2 weeks before for $4,500 that were unauthorized. Thankfully, I could cancel one of them because she hadn't taken it yet, and I was able to lock her access out to the other once I proved that the association had paid for it and not her. I sent her a certified letter, gave her 12 days to return, or I would report the equipment stolen. That equipment did get returned, and I said she could get the online course access back if she reimbursed us, which of course she did not. All right, be consistent. Handle every employee the same way, just like we do with homeowner violation enforcement. This is going to ensure fairness, transparency, legal compliance, and protection from discrimination claims. Finally, review your internal process. Do you have a strong onboarding and offboarding process and a checklist? Checklists are great. Do you have a consistent exit interview process? Do you have device management tools? Do you have signed acknowledgements for equipments or credit cards issued? Take these steps, protect your organization, support your team. That'll ensure a professional offboarding experience for every employee. Thanks.
Going into state compliance wage and hour, I wanted to talk a little bit about the different changes and different aspects of each state. So for DC, we have a minimum wage of $17.95 per hour with tipped employees at $10 per hour. Currently, there are no state-specific laws mandating any breaks in meals. There is a salary history ban. So employers are prohibited from screening candidates based on wage history, requesting disclosure of wage history, or seeking wage history from a candidate's previous employer. For Maryland, we have a couple of different minimum wages that I wanted to point out. So the current minimum wage for Maryland is $15 per hour with tipped employees at $10 per hour. However, we have Howard County at $15.50 as of January 1st of this year with employees of 14 or more. And then tipped employees would be $3.63. Montgomery County is a little bit more unique. It has, as of July 1st of 2025, so employees, if you have an employee count of 1 to 10 employees, you'll be complying with $15.50 an hour. 11 to 50 employees is $16 per hour, and 51 or more employees, it'll be $17.65 per hour. Tipped employees are $4 an hour. Specific meal and rest break rules for retail employers only, so make sure that you are staying compliant with the specific rules for retails. Salary history ban in Maryland is prohibited from seeking wage history from a candidate's previous employer, using applicant wage history to screen or consider them for employment, or using wage history to determine their wage rate. Virginia is their current minimum wage is $12.77. And then we got tipped employees at $2.13. Breaks in meals, right now, specific meal and rest break rules are only for retail employers only, just like it is for Maryland. Going into leave laws for the states, we have DC. Family and medical leave requires employers for 20 or more employees up to 16 weeks of unpaid job-protected family or medical leave within a 24-month period. Then we also have paid sick leave. This will apply to all employers with 1 or more employees, so pretty much everyone. Provides accrued paid sick leave to all employees. The amounts of the days accrued are based on the size of the employer, so make sure that you're familiar with how many employees you have and what the accrual rate is for your specific industry. DC also offers a school involvement leave. It requires employers to allow employees 24 hours of leave in a 12-month period for school events. Maryland, they have a family and medical leave insurance. It does apply to all employers with 1 or more employee. They can get 12 or 24 weeks of job protected paid leave per year for personal and or family medical leave. Effective January 1st of next year, contributions are going to begin for employers over 15 employees. The exact date of collecting the benefits is still being determined at this time, so stay tuned for that and make sure that you're up to date with what's going to be coming in the pipeline. Maryland also has a Parental Leave Act. This law applies to those who employ between 15 and 49 employees in the state for 20 or more calendar work weeks in the current or preceding calendar year and not covered under FMLA. That was the biggest piece that changed this year, was the employers who were not covered under FMLA now gets the parental leave. 6 weeks of unpaid job protected leave for birth, adoption, and placement of a child in foster care. Maryland Sick and Safe Leave under the Healthy Working Families Act is employers with 15 or more employees in the state. They must provide paid leave for employers with 14 or more employees. For anyone who has, 15 or more employees, anybody who is under with 14 or less, they will be provided unpaid sick and safe leave. Many states require similar leave laws, such as jury duty, victim leave, and family leave or voting leave. But not all states provide their own family and medical insurance. So you can see on this chart that I have above, Virginia doesn't have the family and medical leave, but the others do. That's why it's very important to make sure that you're looking at your state-specific laws. HR is always evolving. So we wanted to kind of highlight some of the changes that were recently made. Under federal law, one of the biggest things were the One Big Beautiful Bill. It was effective immediately. So what this means is fewer taxes on tips and overtime. The important part for employers is to update your payroll to identify and track FLSA qualifying overtime separately. The other piece was paid family and medical leave the credit was extended for all employers. So some of the state-specific ones that I wanted to kind of note and highlight were DC, their tipped minimum wage. It's currently $10 per hour, but it will be increasing by 56%. That's a big amount to be making sure that you're staying in compliance with. But increasing by 56% of the standard minimum wage in the course of every 2 years. So every 2 years, it will be increasing. So please make sure that you are visiting the DC website to see what those increases will look like and how it's going to impact your workforce. Virginia's minimum wage, it increased this year on January 1st to $12.77. Maryland, as of October 1st of last year, Maryland employers covered by the federal FMLA Act will no longer be required to comply with the state's unpaid parental leave law. January 1st of this year, domestic violence training is now required for all licensed personal care professionals such as barbers, hairstylists, and cosmetologists. You always want to consider the requirements of employment laws and the organization's policies when interacting with employees. The purpose of these laws and policies are to create safe and fair and productive workplace for all employees. So some of the ways that you can get ahead of constant compliance changes is enrolling into HR newsletters like SHRM. Listen to HR podcasts from reputable sources. Enroll in e-updates or newsletters from your state's labor department and board. Engage in webinars related to HR topics and upcoming compliance changes, general or state specific. Engage in HR services. So some of the questions that were provided to us prior, I wanted to kind of go into a little bit further. Employee relations. I have 2 employees that are always arguing, and they're creating an uncomfortable work environment for my other employees. How can I handle this situation? Well, the first thing you want to do is gather facts. We always want to make sure that we have facts. We don't want to just assume that the situation is one way. We want to mediate the ground rules and company policies. Let's make sure that we are looking at which policies are they really impacting. Let's get both of the employees sitting down and agree on the actions and document the conversation. That way, if further issues continue to impact the workplace, we can go ahead and move forward with the next step in discipline or whatever the next step might be. What should I include when writing up an employee? Well, you want to describe what the discipline is. Why are they being written up? The best thing to do is put the date of the occurrence, any prior warnings related to the incident. That way you can show like a history of this has been an issue in the past, or maybe it's the first time that it's happening. You want to list which company policy has been violated and what the expectations are moving forward. How are they going to correct the behavior? And last but not least, we want to talk about what are the consequences of the failure to improve or correct the behavior. Documenting all of those and making sure everybody is on the same page is crucial. I've had so many clients where they're like, I have managers who are really, really hard at conflict resolution. They avoid conflict. They don't like to have those difficult conversations. It doesn't have to be difficult. It doesn't have to be a huge conflict. It's just simply you're telling the person where they're lacking. They can't fix what they don't know. So having these conversations is very crucial in your work environment. Regularly meet with your employees one-on-one. That way there's no surprises in the future. They know where they stand, what they need to fix, what they need to correct. I highly believe and always talk to my clients about stay interviews. Stay interviews, I feel, are very effective, and it provides an ongoing dialogue between the employee and the manager. This, like I said, it helps minimize surprises whenever it comes time for annual reviews or whenever there's sometimes they do have to get written up, that uncomfortable conversation. Leave of absence and accommodations. Do employees accrue PTO vacation while they're on leave? Well, really, it's going to depend on your employee handbook. It's going to depend on state and federal laws. So making sure that whenever you build out your handbook or your, you have this policy in place, you want to make sure that you are in compliance with state and federal laws and you're practicing consistency with this across the board. Just like Sarah talked about earlier, consistency is key. You can, oh, I'm so sorry. There we go. Can performance management continue during leave? Absolutely, it can. However, you want to make sure that you're addressing pre-leave issues factually, but do not pressure or penalize for taking protected leave. We want to make sure that it's based on their performance. The biggest thing that you do want to make sure that you do is consult with HR. You want to make sure that you're doing it the correct way. Recognizing an accommodation request, like we were talking about earlier. Maybe there's an indication an employee has a medical condition or sincerely held religious belief affecting their work. We want to make sure that we get all the facts and we're able to recognize when there is possibly a potential accommodation request. Wage and hour. I have an employee who continues to clock in early, use the restroom, go get coffee, socialize with their coworkers. Can I change their time card and pay them for the hours that they actually worked? Well, the short answer is no. You can't just change their time card. You have to sit down with the employee, get authorization from them before you change any time. It's always good to get that signed authorization. The other point is there is actually a disciplinary issue with this. If the employee is constantly doing this, knowing that they're not allowed, maybe they're getting overtime because of this. It could be unapproved overtime, and that's an issue. It could be that, you're there. It's kind of like time theft. So you want to make sure that you are having these conversations to avoid in the future. So set clear expectations and give the employee a chance to correct the behavior. That's the biggest thing out of this. If it continues, you will progress in the disciplining the employee with written documentation for them to sign. This has also been an issue for my clients whenever it comes time for an employee forgetting to clock out for lunch. You're in a rush. You're trying to rush out the door and go get your lunch and get your lunch break in. Oh, I forgot to clock out. You don't know if it's truthful. You don't know if it's not. That's not the point. But we want to make sure that we're having conversations with our employees to make sure that they are aware that this is an issue and it needs to be corrected. I have a salaried non-exempt employee. Do I need to track their hours, their time to work? Yes, you do. Just because they're salaried doesn't mean that you don't have to track their hours. A salaried non-exempt employee is actually considered an hourly employee. So yes, their time worked needs to be tracked because all hours worked are considered being paid. I really appreciate everybody's time today. If we have additional questions, we would love the opportunity to answer them. I know that Joe, you will be going into, or the questions will be sent over to Joe. He'll be monitoring and kind of filtering them. So we would love the opportunity to be able to answer in more depth. Suzanne, is there anything that you would like to say?
No, I'm good. Thank you all. You did a fantastic job. We are very, very happy that you were able to put this together for us today. Do any of the attendees have any questions? We do have a raised hand. So let's see what we got. And I'm not seeing it. If there is a question, can you please put it in the chat box so that we can pick it up? Oh, okay. Nope. Question, are there time tracking? Let me get it there.
I can't hear the
Let's see.
question, and I can't read it. I'm sorry.
No. It's okay. Let me just get
I can
there.
read it.
Are
Want me
there
to read
time
it?
tracking requirements for salary exempt employees?
No. So if for a salaried exempt employee, you do not have to track their hours. However, there are going to be times where you can deduct hours from their pay. If they miss a full day, for instance, you do not have to pay them. However, if they do work a little bit, like even like an hour of that time, that's kind of one of the benefits of a salaried exempt employee is getting paid for their time.
Got it. Anybody else? I just wanted to make it clear that we are absolutely more than willing to share the recording for this webinar. And if there are no further questions, I want to thank Joe, Emily, Corinne, and Sarah for sharing their HR knowledge and experience with us. Please know that each member of the speaker panel is absolutely willing to address and follow up on any questions you may have after today's session. Please note the contact information provided on the last slide. We are so very grateful to Landmark Payroll for sponsoring today's session. The chapter's educational programs would not be possible without this kind of generous support. As you may know, the Washington Metro Chapter signature event is 1 month away. We hope that you plan to join us for the 2026 Conference and Expo scheduled for February 27th and 28th at the Washington Convention Center, where we will celebrate 50 years of innovation and community with a full complement of education sessions and over 160 exhibitors offering the latest in community association goods and services. We are also excited to be hosting our first ever membership recruitment coffee at the chapter office on February 10th. Not a member or know someone who should be? This is the perfect opportunity to find out what WMC CAI can do for you. For more information on chapter news and upcoming events, please visit the chapter website at caidc.org. Chapter staff will be sending a survey within the next several days. Please complete it as we need your feedback to help us tailor our education programs to meet your needs. Your completed survey will also verify your attendance for CEU credit. Once we receive your completed survey, you will receive CEU for this session. Thank you again for joining us, and we look forward to seeing you soon. Enjoy the rest of your day.
Thank you.
Thank you, everyone.
Thank you, everyone. Have a great
Thank
day.
you.